This week, I've been tasked to make a short YouTube video discussing a key concept about public law. So, if I can take a break from Silksong for 5 minutes, you can take 5 minutes to listen and maybe even learn something. So, let's talk about judicial review. Judicial review is one of the checks and balances that the Supreme Court uses to keep an eye on the executive and legislative branches of our government. So think the president, his cabinet, and Congress. This power specifically gives the Supreme Court the ability to declare an executive or legislative act unconstitutional, which is a pretty big deal, as is a major part of protecting rights of U.S. citizens like you and me. Now it's time for a quick history lesson. So, where did judicial review come from? And what do you need to know about it? To look at the birth of judicial review, we need to go all the way back to the early 1800s and tell a story about some founding fathers and a landmark Supreme Court case that changed a whole lot about how our legal system works today. To do this, we go to 1803, where the Supreme Court case Marbury v. Madison begins. Now, the facts of the case are as follows. Before leaving office in 1801, at the last minute, Federalist President John Adams appointed a series of new judges and justices, nicknamed the Midnight Judges, to the courts. And this was in order to sway the power of the courts to the Federalists, and also as kind of a final middle finger to Thomas Jefferson, who secured the election. Now, this is important because up until now, this is the first time in United States history that there's been a party change between presidents. So, when Democratic-Republican Thomas Jefferson took power, only problem was some of the midnight judges hadn't gotten their commissions to, start being a justice yet. One such man was William Marbury, who was appointed to be a judge in the District of Columbia. But when Marbury didn't receive his commission, he went to the Supreme Court to petition for something called a writ of mandamus. Fun fact, mandamus is Latin for we command. And he did this so that Secretary of State James Madison would be commanded to issue him his commission. But only problem was Madison refused. So, now for the meat and potatoes. After deliberation, the Supreme Court discovered that Madison's refusal was, in fact, illegal. But they didn't tell him to give Marbury his commission. And you might be wondering why. So, here's where things get interesting. The court held that due to the Judiciary Act of 1879, which is what allowed Marbury to bring his case to the Supreme Court and ask for his commission, was unconstitutional. And that means they were unable to grant him a writ of mandamus. Even though Marbury did everything right, it didn't matter because it would extend outside of the jurisdiction of the Supreme Court. So, in conclusion, Chief Justice John Marshall ruled that the judicial branch, or Congress, could not pass laws that would attempt to change the Constitution because of a little something called the Supremacy Clause, or the second clause of the Sixth Amendment if you're fancy. But this established precedent for judicial review. Okay, quick history lesson over. So, before I leave you guys today, let's look at some important examples of the Supreme Court using judicial review to establish and protect some very, very important rights we have today. First, we got a landmark case. I'm sure you've heard of it, Brown versus the Board of Education, that overturned a very old, very wrong decision, Plessy v. Ferguson, and declared it unconstitutional to segregate in our schools and our institutions. Or how about Miranda v. Arizona, which ruled that pigs have to inform you of your rights before they detain or interrogate you. These protections and many others all of us enjoy today were established by the power of judicial review, which is one key concept of public law that it's pretty good to have a handle on.